The Justice and Development Parties, AK Party, continuous efforts to manipulate the judiciary through ad hoc courts, judge and prosecutor reassignments and arresting judges have been criticized by legal experts for undermining the principle of natural justice, which prohibits the establishment of extraordinary courts that displace jurisdiction properly vested in courts. Though the AK Party was unseated from power after the June 7 general election, the interim AK Party government continues to engage in a series of controversial decisions by hiring an additional 5,000 judges and prosecutors and reassigning some of those jurists who made decisions that run contrary to the government's wishes, while Penal Courts of Peace, which were formed in June 2014, continue to detain, arrest and try government dissenters. The principle of natural justice is a fundamental guarantee of the right to a fair trial, meaning no one can be tried by anyone other than a pre-established tribunal or judge. Setting up extraordinary and emergency courts like penal courts of peace are thus forbidden, according to the principle. Also, a judge who hands down a ruling cannot also be removed from his post on the grounds that the verdict caused uneasiness within the political administration, the principle says. However, a judge who recently ordered the cessation of construction work on 2 roadways connecting the in-progress Third Bosporus Bridge has been reassigned by the country's top judicial body, which has been subordinated to the government following an election within the body. Judge Serkan Mangal from the Istanbul 8th Administrative Court that cancelled construction plans for the roads leading to the planned third bridge in the Beykoz district and the Sarıyer Rumlifanri neighborhood of Istanbul on June 8 was reportedly reassigned on June 11 by a decision by the Supreme Board of Judges and Prosecutors, HSYK. The judge was assigned as an investigation judge, distancing him from making any rulings. The Third Bosporus Bridge project had been defined by then Prime Minister and current President Recep Tayyip Erdogan as one of the greatest projects in modern Turkish history, along with several others such as the Third Istanbul Airport. Project court set up after alleged offenses committed. Lawyer Kadir Gökten told today's Zaman many practices engaged in by the government in the judicial system such as establishing penal courts of peace and conducting trials in these courts following police operations against dissident elements of society are obvious instances of the breach of the principle of natural justice. According to the principle, any trial should be held by courts or judges that exist at the time the alleged offense was committed. If extraordinary and special courts are formed to handle those alleged offenses and suspects after the offense was committed, then these courts cannot be defined as natural courts and these judges are not natural judges who are capable of trying the suspects. All these processes mean the destruction of the principle in question, Gökten noted. After the eruption of the December 17, 2013 corruption scandal, implicating Erdogan's inner circle and some key figures inside the then AK Party government, Erdogan vowed to wage war against any elements within society that were behind the corruption operation by exerting full control over the HSYK and setting up courts designed to obey the government's instructions for the dissenters. Thousands of people, including police officers, journalists, students, judges as well as prosecutors, were arrested by these penal courts of peace on baseless charges of being a member of a terrorist organization, insulting Erdogan or disclosing state secrets. Gökten also pointed out that removing a judge from his post while a trial is ongoing is against the protection provided to judges and prosecutors by the Constitution under certain articles mentioning the separation of powers, adding, such a change was made to replace a judge with one who will rule in line with the government's demands as confirmed by the latest removal of a Judge Mangal. This is another explicit instance of the violation of the principle of natural justice. Lambasting the decision to remove Judge Mangal from his post, lawyer Metin Gundai posted several tweets stating, if a judge who hands down a ruling that is disliked by the political administration is removed from his position, then judicial immunity granting a judge complete protection from personal liability while exercising their judicial functions cannot be mentioned. Professor Tset Özcan, one of the main authors of the Turkish Penal Code, TCK, and the Code on Criminal Procedure, CMK, recently wrote on his Twitter account that the newly elected parliament should immediately repeal those penal courts of peace. Our expectation from the newly elected parliament is to withdraw the law on these courts, which is clearly unlawful, and make the necessary amendments to return to justice, Ozgen tweeted. Judges arrested for ruling to release Karaka, police officers. In a similar vein, Judges Metin Ozslik and Mustafa Basir were arrested in May for ruling for the release of Samanyolu Media Group CEO Hidayat Karaka and 63 police officers who were in pre-trial detention for months, violating the principle of natural justice since the judges who replaced Ozslik and Basir who were prevented from performing their duties are not expected to uphold the two judges' decision to free Karaka and the police officers. Meet Göktuğ, a former chief prosecutor of the now-dissolved State Security Court, DGM, told today's Zaman Penal Courts of Peace were designed to hand down rulings in line with the government's instructions. Removing judges from their post and designing courts to adhere to government instructions does not comply with judicial independence, revealing their politically motivated nature. Arresting judges is an explicit violation of judicial immunity. These judges are unquestionably replaced by pro-government judges. If judges and prosecutors are threatened with punishment over their verdicts, then no judge and prosecutor can be expected to do their job in a free and independent manner, Göktuğ stressed. Regarding the breach of the principle of natural justice, Göktuğ underlined that if an offense was committed in Ankara and a penal court of peace ruled for the arrest of the suspect, then it is an obvious violation. If an unauthorized and irrelevant court makes a decision on a case, or if a new court is established especially for a case, then it means the principle is severely violated, Göktuğ added. As part of the damage done by the government to judicial independence and judicial impartiality, its recent move to employ an additional 5,000 jurists has ratcheted concerns that it is planning to continue preventing the judiciary from acting freely. In addition to the planned hires, thousands of others were reassigned or removed from their posts. Reminiscent of independent tribunals set up in early years of republic. Natural justice is a basic principle of criminal law and, according to Kemal Gözler, a prominent professor of constitutional law at Uludağ University, the principle of natural justice requires that a court that will adjudicate a dispute be legally established before the emergence of that dispute, prohibiting a court from being formed after the incident, he wrote in a recent article. Thus, any interference by the executive body in the judiciary is prevented, which protects the defendants because the judges trying them have not been especially assigned to try them. However, Gözler notes there are claims that 6 penal courts of peace were especially designed to arrest those police officers and others who are thought to have links with the parallel state, a term coined by Erdogan to defame the faith-based Gülen movement, also known as the Hizmet movement, because he believes the movement to be behind the revelation of the massive corruption allegations inside the government. Just 5 days after these judges were assigned to the courts in question, a large number of police officers who are allegedly members of the parallel state were detained and arrested in the following days, confirming the claims of maliciousness in the process of the setting up of these courts. It is obvious that the 6 judges were determined from the pro-government elements. If the situation is such, then the penal courts of peace are equivalent to those independent tribunals established in the early years of the Republic, Gözler wrote. Independent tribunals were established to prosecute those who were against the system of government and many were subsequently executed.